through December 31st, 2019 for residential real property built prior to January 1, 2005. From City Manager's Office.
Mayor, the ordinance is here for your opportunity to consider. We've had several citizens raise concerns over follow-throughs of action of landlords to take steps before the new state law goes into effect and have to change the year. If you wish to take steps to resolve that matter, this would require an urgency ordinance such as what is presented tonight. There's no requirement. It's an opportunity that's available to you for consideration.
And the City of Los Angeles recently did exactly this.
City of LA and several other agencies have implemented it. It's a gap that was created by the legislation that the state missed what would be a consequence to the actions they took. So several agencies have taken action. I think the city attorney has a couple of cities.
I believe Long Beach was looking at it, Burbank, Culver City, and I believe up north, I can't remember who was doing it up there, but there's several cities trying to deal with the unintended consequence of the law. And basically, as a little backstory, as City Manager Jackson pointed out, the law that the state passed goes into effect January 1, and basically what that does is it puts a cap of 5% on increases and plus cost of living increase of, so no, with a max cap of 10. As the City Manager said, 1482, the Assembly bill, since it goes into effect in January, a lot of the landlords, from their perspective, want to try to get to market value. And so what they're doing is sending out massive evictions. We've had a letter and other citizens say that everyone in their building got an eviction notice. There was a question from one of the Councilman Matucci had asked me if there's any statistics that we have, and unfortunately we do not. The way evictions work in California is the landlord can do two ways. There's for cause, so if you're committing a crime, not paying rent or anything like that, that's one process. And then there's no fault, essentially, no without cause. And that one is essentially just giving a notice, depending on the length of your tenancy, 30 to 60 days, the standard one is 60. And so once the bill was signed on October 8th, a lot of landlords started looking at the process, and that's when these notifications started going out. So the next step after the notification was if the people don't move, then there's what's called an unlawful detainer. And that would be the only way we would be able to try to track it would be through the courts. But there's no way for the city to track the number of notices that have gone out other than reports from tenants.
I was somewhat surprised that we have almost 23,000 households that, well, we don't know if they're affected by 1482 because, well, I guess they are because most of our housing stock was built prior to 2005. So, okay, we have Councilmember Chen.
Mayor, I need to apologize because the previous item, when you asked for a motion to accept the file, I thought we were going to have a subsequent follow-on to talk about draft ordinance. I didn't know how that was captured, if we're still doing that, or that had to be part of the motion. Because you went on 9B, so I didn't know.
Just the council acted on that as just a motion to accept the file. If the council, that was not the council's intent, under the council rules of order, you can do a motion for reconsideration. What I would do is wait till 9B is done.
Okay.
And then you can come back, and if you want to do a motion for reconsideration, since it was a unanimous vote, anyone can make the motion. And then if that's the council's intent was to direct staff to look at an ordinance, you can just do a motion for reconsideration, so you vote on that. Then you actually have the motion to actually reconsider it and change what you'd like to change.
Okay.
So that
Thanks for the clarification. I thought I was going to have that opportunity, and went to 9B, and I kind of got stuck in the middle. Sorry about that.
Councilmember.
Jesus.
Thank you, Mayor. I had a question for staff on this item. I hear some vague comments about how many people have actually complained to the city about having an eviction letter delivered to them? Do we have any details? I recall seeing one email specifically about someone who said they got evicted.
Right, we've had some individuals who've indicated, maybe 2 or 3, not a significant number at this stage. We've also had some of the individuals at council and other places say that they are aware many of their neighbors have received similar.
So
Actions.
let's say that hypothetically, a large apartment unit gave everybody eviction notices already, but we just don't know about it. And we pass this ordinance, would this ordinance affect those eviction notices?
Yes, it would affect all eviction notices where the notice period is still running and the tenant is still in possession. It would not affect anyone that had received a notice of eviction earlier and has left the premises or has had an unlawful detainer issued against them. But anyone where the period is still running, it would be effective against.
This is also only no fault. This is not for
Correct.
cause.
This would not,
Understand.
if
Yeah, I understand.
it was for other reasons, then that would not.
Right, I wanted some better hard statistics on how often that we know that this has happened since the state law was passed, and how big is the real problem we're trying to address?
As the city manager said, that what we've had is some, the one lady who spoke and also sent an email, and then there has been other, I think, phone calls that have come in, and then some staffers have mentioned in passing to me that they had received it, and that their whole building had received the same, but I don't have any hard statistics, and if that's, I guess that's something that the city council could request to put the item over and ask for more information. I just
Please.
don't
Let's just hold
know how we
on.
would get those.
Yeah, I understand, and the reason I ask is obviously, if we're gonna consider making an ordinance, I'd like to have more than 1 or 2 people who have actually made a complaint. And so that makes me a little hesitant to want to put a new ordinance in place if it's not a big issue. I'd be happy to listen to more details and hear what the public has to say before I make any decision.
Mr. Matucci.
Thank you, Mayor. Now, I know that some cities have made it retroactive. I couldn't find any verbiage in there that made this retroactive. And if it's an emergency ordinance, it would be effective tonight, right? If it gets voted in.
Correct, and this doesn't go into the past, so if someone's been evicted prior to tonight, this wouldn't affect that. If someone's had an unlawful detainer issued by the court, that also wouldn't apply. But anyone that was still within the notification period, one of the first that we spoke here, I think hers runs in mid-December, so it would apply to that person, as long as they're still within the notification period of the thing, there hasn't been an unlawful detainer, and they're still in possession. So if they've surrendered and left, it would not apply to them.
Okay, so these are just active cases.
Correct.
Okay, and so this will actually stop, let's say, dad vacating one of the units so that the daughter can move in. This would actually stop one of those.
That's I would say any situation, yes, where they've given a notice to vacate, and that time is still running, and the tenant is still in possession. For whatever factual reasons, whether it's the situation you said, or a landlord that's trying to empty out the apartment complex, trying to get their rents up to market.
Okay, and so I would imagine, now my understanding that it's not just cause, if it's a son or daughter moving in, you can't do that unless you mutually agreed upon, right? Is that, plus we're technically just accelerating what's already gonna be happening January 1st, is that pretty much it?
For the just cause is, if you look at page 5 of the ordinance, of the item, which is page 3 of the ordinance, we list out essentially at fault. So if you defaulted in rent, the landlord can evict you. If you've breached your lease in any material term, they can do it. If you've committed a nuisance as defined by the Code of Civil Procedure, if you've committed a crime, especially this is criminal threats, if you've sublet your property in violation of your lease, refusal to allow the owner to enter and inspect under the Civil Code and the Health and Safety Code, using the premises for any unlawful purposes. In the past, it's been like red light or drug situations. And then obviously if it's a manager or manager's agent, the number 8 is dealing with if you've been terminated, you don't get a stay if you're the manager. And then finally, if you've failed to get full possession after the period has run. So those would all be considered justified under our ordinance, and the landlords could give that notice. It's the no fault ones that the city was dealing with. And obviously, the council needs more information. Staff can do its best to bring that back to you.
Let's table this.
I do feel that this came, I understand that there's a time crunch, and I know it negatively affects some tenants. I do believe that we're really kind of joining forces with Sacramento and chipping away property rights. I think, parents vacating a space of a property that they own to put somebody in there that they love, or maybe they want to give it to a homeless guy, But whatever the case is, I mean, I really do believe that this is something that we may, in my opinion, should have done on a night that it wasn't a regularly scheduled dark night.
Right.
Possibly next meeting,
Yes.
just because I think we need to give both tenants and property owners the ability to come here with sufficient time to come and argue their case.
If the council would like to continue this to another date, that's within their authority.
Yeah, I really do think that that's the
Yeah.
path we should take. Listen, I have received several emails, especially the Englewood Board of Realtors, talking about not just tonight, but also Englewood is voting tonight. They probably already voted by now to doing a rent control of 3% a year maximum, which well below what the state came in with. So I mean, we're really chopping away at not just property rights, but even we're chopping away at really of a motivation of even owning residential property. Little by little, I mean, some of these residential properties are going to be torn down and put other types of use, because you can only regulate so much until people get tired of owning these types of properties, especially in California. So I would say that we move this to next week's meeting, just so that we can properly get people in to argue their case, whether you're the tenant or the property owner. I don't think this proper to put on an agenda of a dark night. Today was supposed to be a special meeting just for the homeless joint meeting, but those are my thoughts. Thank you.
Good job. We have a number of people signed up.
Yes, Your Honor. Amanda Mendoza,